Let's move on to the third speaker. I'm delighted to introduce Professor William Twining, Emeritus at University College of London, whose topic of presentation is what can the law as a discipline and a legal experience contribute to evidence as a multidisciplinary subject? Or rather, according to the new title of the written text, evidence as a multidisciplinary field. Notes on the question: what does law and the discipline of law have to offer? Over to you, Professor Twining.
Thank you. Is this audible? Yeah. I have the last word at this conference. And usually that is the thing that a lawyer asks for. But I'm reminded of when I taught, when I used to, like a good Jesuit, seize the very first week of study of first-year law students, forgetting that in parlance of English universities, this was Freshers' Week. That is to say, what my audience was a bunch of 18-year-olds who were away from home for the first time, at university for the first time, had joined 23 clubs, and were hungover. And one of the congratulations that I think needs to be given for this event is the stamina of the audience. But there are a lot of other congratulations to the organizers, to Geordie, to all the old friends and colleagues and new friends that have been gathered together, and not least to the translators. I think the simultaneous translation has been absolutely magnificent, and we should applaud them. We've already heard how evidence in legal contexts benefits immeasurably from other disciplines and experiences, practical experiences elsewhere. Adrian Zuckerman, Amelia Amaya, Ron Allen, and a lot of others drew on disciplines other than law to illuminate what they were saying. Today I want to reverse the question and move from importing into law to what we might export to other disciplines and other contexts of practical decision-making. First of all, who are we? I think we're much more than a bunch of specialists in the law of evidence. I think we are collectively and to a large extent individually experts on evidence in legal contexts. And that's a much wider conception of the field of evidence in law than just the law of evidence and some of the concepts and doctrines associated with it. And I'm a bit of a legal nationalist. I actually am rather proud of my discipline and think that we are very privileged to have this terrain over which we have at least partial hegemony. And so I think what we have to offer is much more than just the traditional idea of evidence as a legal subject. And to whom might we offer some insights or concepts or debates or whatever we might have to offer? Well, is there anyone in this room who hasn't drawn an inference from evidence in the last 24 hours? Speak to me afterwards. Is there anyone in Girona who has not drawn inferences from evidence in the last 24 hours if they've been conscious, and possibly even subconscious? We've heard in this conference people from other disciplines who found in the legal context, not necessarily what the academics have been saying, something special about the legal environment. Toulmin has been regularly cited. Susan Hark has been regularly cited. Jonathan Cohen, and David Shum, about whom I want to say something in a minute. A couple of anecdotes. I once went to give a talk at a police college to people who were being trained as detectives. And after I'd been going about 10 minutes, the instructor said, "That's logic. That's academic. We're police officers." As if Sherlock Holmes wasn't the patron saint of detectives. Let me start with a parable. In 1754, Chief Baron Gilbert, who had written his books and died sometime before it was published in 1754, published really the first book that was essentially on evidence as a field in the English language. About 50 years later, Jeremy Bentham used Gilbert as prime target to attack in his campaign against the English law of evidence, but also the whole procedural context and a great deal more. Gilbert's theory of evidence was essentially a hierarchy, a set of hierarchical rules of weight, with official documents under seal at the top, and then official documents not under seal, and then private documents and unofficial documents under seal, and then private documents not under seal, and so on down, with oral testimony being at the bottom, almost at the bottom. In the 1980s, a movement called evidence-based medicine began. And in the early days, they have since been a bit more moderate. They produced a hierarchy of types of evidence in terms of their probative value, with repeated random clinical trials at the top and virtually nothing else underneath, with exclusion of practical experience of general practitioners, expertise which wasn't backed by clinical trials, and the idiosyncratic intuitions of patients. And those weren't just put at the bottom, they were excluded in the early days of evidence-based medicine. When evidence-based policy came along after that, there were similar extravagances, although immediately there was a reaction against that, and so this has been a less clear field. But the belief in hard science as the basis for policy remains the center of the evidence-based policy movement. One of the pioneers of evidence-based medicine was a turncoat, a colleague of mine in medicine at UCL. And having written the standard book for medical students on evidence-based medicine, she produced a book called Narrative-Based Medicine, and also started to attack some of the excesses of the evidence-based medicine movement. I did a Google search last week of institutions specializing in evidence in England and Wales. And let me just give you part of the list. The Coalition for Evidence-Based Policy, the Campbell Collaboration on Evidence-Based Policy, the Laura and John Arnold Foundation on Evidence-Based Policy, What Works Clearinghouse, Evidence Network, Alliance for Useful Evidence, Society of Evidence-Based Policing, excluding logic, the UK College of Policing, which I think is what I went to before, and the Cochrane Institute, which synthesizes evidence in medicine. A huge operation with money that lawyers have never dreamed of. I mean, it is really well funded. And they have so many. I listened a couple of weeks ago to a talk on this by specialists in trauma. And they have so much in the way of research reports on traumatic medicine that they don't even consider all evidence produced by random, repeated clinical trials. They actually grade that, and they just do not have the time or resources to consider any other kind of evidence, and then they synthesize it. So I think there is a question what their working assumptions and working concepts are, and whether there is a throwback to Gilbert in 1754, because the style and framework of this is very similar. I've been involved in thinking about this for some time, mainly in a rather dilettante way, and my start has been with the work of David Shum, who, as most of you will know, is a psychologist and statistician who produced, as his first major work, a 2-volume work called Evidence and Inference for the Intelligence Analyst, which is about this thick. And it didn't sell very well because it was a bit too thick for intelligence analysts. It's actually probably one of the clearest statements of his views that has appeared. He then produced, a bit later, a work which his friends teased him for, which was called The Evidential Foundations of Probabilistic Reasoning. And we said he ought to sell the rights to Hollywood, because this would really be a stunner in the movie industry. Essentially, this rather awkwardly titled volume took about 8 different disciplines and compared them in terms of mainly their basic concepts, but to some extent, some of the basic, more general methods. And, you know, it is nice for a legal nationalist to be told that the most important discipline is one's own, is law. And I think he rather overstated that, and I would want to modify his claims. But he wasn't only talking, although the way he said it, it was about academic lawyers writing about evidence in law. He was really actually dealing with the mass of material we have in trial records, in other kinds of legal records, in all sorts of other sources which are part of our domain. And historians have long recognized that. Making, for instance, said that annals of legal and social history are to be found in the legal records in England. Ron Allen suggested that Shum's approach is top-down. I'm not sure what that means, but I don't think that's true. He was mainly concerned, still mainly concerned, with cross-fertilization between disciplines and between decisional contexts. And it's pretty specific, and although there are a few fairly abstract concepts he deals with, most of his work has been at a much more applied and concrete level, sometimes middle-order theory, sometimes very particular, in systems engineering, in intelligence analysis, in a number of disciplines in addition to law. Police investigation, he did some really interesting work. In the 1990s, Terry Anderson, my collaborator, and I did start a very modest project at the Netherlands Institute of Advanced Study, in which we got together, there were 5 rather disparate groups, largely from the humanities, and we created an evidence group to try out Sham's approach in relation to the disciplines that were represented there. And we had some rather bizarre collections. Terry Anderson did a Wigmorian analysis on the date of the death of the Sumerian language. I had long dialogues with a theatre historian who was using bad art as evidence of the commedia dell'arte, on questions of clothing and gestures and things like that, and where they were metaphor between 2 disciplines, because the theatre historians didn't think this was very reliable kind of stuff, and the art historians asked why was she so interested in third-rate art. But we had great fun with that, and in the end, she did produce something on the commedia dell'arte. And then there were 1 or 2 other rather bizarre juxtapositions. But what came out of that, if anything, was that the hypothesis that we were all concerned with inferential reasoning based on evidence towards conclusions was a shared matter, and there wasn't very much skepticism. When it's moved up, not mainly through me, but because evidence had become very newsworthy at the turn of the century and the early days of the millennium, large grants were being offered for ambitious projects in England on evidence as a field. And largely through the efforts of a statistician, Philip David, UCL managed to get a £1 million grant, which in terms of humanities and law is a lot of money. We had economists and medics who just thought this was a fairly ordinary grant, but we were rather overwhelmed by this. When Philip David circulated all departments in University College, he had responses from 40 departments. But that was because there was money around. In the end, when we got the grant, about 20 departments had people who were involved. And as Ron commented in his talk, I was a bit disappointed by the outcome of this process, but that is not to say it was a total failure, and in fact some of us have tried to revive it since then. I think there were 2 main reasons for it not being as satisfying, at least for me. First of all, we have a number of refugees. There was no interest in the hard sciences except from computer science and medicine. And we had some refugees from those areas who were essentially fleeing from the over-scientific culture that they were involved in. And the trouble was they got postmodernism. And so they suddenly got Richard Rorty. And Richard Rorty isn't really a good starting point for study of evidence, of the interdisciplinary study of evidence, because the real question is whether evidence means anything in that kind of postmodernist, well, I don't know if it's postmodernists of that kind don't distinguish between epistemology and ontology. I'm not sure that it's an epistemology that postmodernists project. And so that rather undermined the core of the thing. But there were some very interesting things done, and I learned quite a lot about evidence-based medicine and a little bit about evidence-based policy in the process. I still believe that the question, obviously more general, can there be a useful sub-discipline, not defined just as a field of a very far-reaching kind? If you think about disciplines, you start with A, which are involved in evidence. You can have agronomy, and you can have agriculture, and you can have astronomy and astrology, if you like, and on through the alphabet to Z, with quite a lot of interesting enclaves, like theology and the debates about the probabilities of the existence of God in the Royal Society in the 17th century, and so on. The history transcends discipline. But there hasn't been, other than in law, an institutionalized subject of evidence. We have people who call themselves evidence scholars. I don't know of people in any other discipline who have that. We have journals, we have conferences, and so on. So it has been institutionalized, particularly in the common law world, in a way that although, say, epistemology and logic and so on have, and historiography, for instance, have treated this as important, it hasn't been, as it were, plucked out. I think one of the lessons of these earlier projects, and David Chum himself had made this before, is what's been a theme of this conference, which is at the core of our subject, is the idea of inferential reasoning from evidence towards conclusions which may then lead on to decisions. And by incorporating both conclusions and decisions, one can, as it were, incorporate both the theoretical and the practical applied divide within one area. So what might we be good at? And to some extent, my motive today is to try to stimulate some of you to think of this in terms of your heritage rather than mine, because I'm very much in the common law tradition, and one of those linguistically deprived Anglophones who isn't familiar with all sorts of literature that I should be familiar. Well, one thing is concepts. And in my paper, I listed, if I can find them, some well-developed concepts which have been well-developed in law and which feature or don't feature in other disciplines. Admissibility, let's start with that. I was suggesting that the problem with the extreme version of evidence-based medicine was that they were treating most kinds of evidence in medical research as inadmissible as a practical matter, and actually to some extent as a theoretical matter. And that's still happening. Ancillary evidence, authenticity, credibility of witnesses, I think some of Shum's work on that is very interesting. Catenate inferences, cognitive competence and cognitive consensus, which Jonathan Cohen, I think, made prominent in legal evidence discussions, and which is really important in the English system, where so much of our adjudication, and our fact-finding, particularly in adjudication, is carried out by lay people. the working assumption that nearly all adult members of society are capable of doing this kind of reasoning. And then, much more dubious, that with regard to background generalizations, Toulmin's warrants, there is some consensus about what these generalizations are. That's obviously very dubious as a generalization itself. And then other terms that come into the discourse of evidence in our discipline. So, general experience. Wigmore's Principles of Proof was subtitled as found in logic, psychology, and general experience. And in fact, the psychology element was redundant because his view of general experience included all the various sciences as well as common sense, prejudices, folk tales, Cinderella, and so on. In other words, general experience is the category into which Toulmin's background generalizations is lumped, and it varies from repeated random clinical trials down to the most terrible kinds of prejudice. They're all that. And so, in a funny way, we've been experts on common sense. When a course was introduced at the Inns of Court School of Law in London called Fact Management, the students, particularly the students from Oxford and Cambridge, rebelled against it, saying, we don't need to worry ourselves with this sort of thing. It's just common sense. So why are you wasting our time doing this? And then they were given a few exercises in quite elementary construction of arguments and analysis of evidence. And they said, this is too hard. We don't have time to do this kind of analysis as exercises in this rather pressured course. Too hard, too soft reaction to concepts. And then, of course, sociologists in particular don't like the term common sense and tend to condemn it, even though what else do we have in making our inferential steps from evidence to conclusion? There are a lot of other terms which we are familiar, different ones in different systems. Persuasive effect, probative value, real evidence, and then, of course, standards of proof, which we've heard a lot about, reliability, relevance, etc. And one question is, to what extent are these concepts at all shared with other disciplines, and to what extent, insofar as they're not shared or they're used in different senses in other disciplines and other decisional contexts, might they be illuminating? Or might it be that there are really more fundamental differences than we might think? If you take relevance, one could do a little project on looking at the use of the concept of relevance and related concepts in, say, 6 disciplines. And if you started with linguistics, you would find that relevance means something completely different from in law. But in a lot of other disciplines, it's used sometimes quite casually to mean, in what I think is the central concept of evidence in law, evidence is a word of relation. A is evidence of B, and relevance is implicit in the concept of evidence so interpreted because it's relevant evidence, which is either probative or negating. And here I think Ron and I have quite different views. I think if you are an evidence scholar, you're landed with relevance as a central concept. What else do we have to offer besides concepts? And I want to come back to concepts later. Well, we have a rich theoretical literature, some of it developed with people from other disciplines, but especially in the common law tradition, I'm familiar a little bit with the aspects of the civil law tradition, particularly in France. From the 19th century on, theorizing about evidence was really quite an industry. And the names that have survived are Bentham, Thayer, Wigmore. I think Fitzjames Stephen didn't quite survive. And then I think Jonathan Cohen's take on Pascalians against Baconians has become very central to this. So there is a heritage of theorizing about inferential reasoning in legal contexts, in which some of the questions also arise in other contexts, in other disciplines, in other decisional contexts. But of course, there's a much longer history. When I started taking an interest in evidence in the 70s, my daughter came home from school, and her school book for her 16-year-old exam for 16-year-olds was The Murder of Herodes. So I read that, and it was all about inferential reasoning and so on. You can find in the classics, in the history of rhetoric and so on, an immense heritage not confined to law. But then law seems to have taken off a bit more on its own. And so rhetoric split up, and law broke away from that. The title of this conference breaks with the tradition of jurisprudence in treating legal reasoning as having something to do with evidence, legal evidential reasoning, whereas nearly all Western jurisprudence, when they have a topic of reasoning, it's reasoning about questions of law, which is obviously closely connected with the heritage of the doctrinal tradition and so on. But the legal philosophers have been very resistant to thinking about the relationship between reasoning about questions of law and reasoning about questions of fact, and the grey area between, because the distinction between law and fact is a very problematic one. And so you have two bodies of literature which, on the whole, have not talked to each other. Well, I think if you started to think about the structure of the very classical case of legal reasoning about questions of law, and the structure of sort of a Wigmorian model of reasoning about questions of fact, there are many more similarities than one might assume. First of all, these are structured by anchoring in a hypothesis. And in law, as far as evidence is concerned, the concept of materiality, the hypothesis which is provided by the substantive law, like the law of murder, is something historians don't have, the concept of materiality. And my experience of historians when I debate with them is they're rather inclined to shift hypotheses without shifting their argument if they get into difficulties. And there's a whole set of questions about hypothesis formation, hypothesis refinement, the changing of hypotheses in process of litigation, for instance, which I think could be very illuminating in regard to other kinds of inquiry. We are all aware, and Adrian Zuckerman reminded us of this, of the dangers of settling on a hypothesis too soon. We have a phrase in English, suspect-driven inquiries, and police are trained not to settle on one suspect and get into confirmation bias on that too soon. But they then quite often make difficult decisions in the investigative process as to when they eliminate hypotheses, when they get down to one or two suspects and so on. But it's the formulation of the hypothesis, the precision in which hypotheses are worded, the extent to which there is room for maneuver once there has been an anchorage, decision to prosecute, charge, there are very specific charges, and then the proceeding goes on from there. I agree with Ron that sometimes the hypothesis does change in some ways, but nevertheless, the anchorage in a hypothesis defined by law is a really interesting phenomenon that I don't think we have explored as much as we might have, particularly outside legal contexts. Admissibility. Someone yesterday, I think, made a move which I think is very useful and which brings us back to evidence-based medicine. Quite often lawyers speak, particularly common lawyers, speak about exclusion of evidence as stopping the jury from hearing it. But actually, within our received theoretical tradition, admissibility, like relevance, is within a framework of argument. And with certain legal doctrines, really it's a question of use. For what purposes may a particular item of information be used or not used? So, for instance, under old hearsay doctrine, you could admit hearsay, evidence of hearsay, as evidence that the fact the statement was made, but in various circumstances subject to exceptions, you couldn't use it in terms of being evidence of the truth of the proposition. Well, Thayer, I think, got this right, that the structure is a structure of argumentation, which fits some model or models of inferential reasoning, and admissibility is really about use within an argument. So, transfer that, say, to Ronald Dworkin, who argued, although occasionally backsliding a bit, that judges may not use policy arguments, but they may and must use principle arguments. Well, Dworkin was excluding policy arguments from his model of reasoning. And so any situation where you have, you're approximating to this model of reasoning, where certain kinds of consideration are excluded, this is really fits under the concept of admissibility as we've thought about in law. So if you think about appointments to jobs, and if the people involved in the appointment may not take account of race or gender or age or certain other things, those are inadmissible reasons for appointing a person and justifying the appointment. In other words, the concept of admissibility moved outside the legal context is transferable, although, again, we'd have to look at other specific contexts to see what this means. And I think this is true of the main evidentiary concepts we have in law. Materiality, given by substantive law. Relevance, there are no rules of relevance. I think most people accept in this context. Weight, Wigmore put it, relevance and weight are matters of logic and general experience. There are no rules. And in one instance, he said to talk of rules of weight is akin to moral treason on our profession. And so, admissibility, law of evidence, materiality, substantive law, relevance and weight, no rules. So we're back to common sense reasoning, or however you like to put it. I think we have some other things in our locker that we should value, which may be relevant then to exploring people's working assumptions and concepts and the way they think and the way they should think in other contexts, in non-legal contexts. The whole technological and legal literature on scientific evidence, I think, has a lot to offer outside the legal context. I've mentioned archives. Archives are a particular hobby of mine, but we've been rather irresponsible in terms of preservation of legal records, and also rather blind. Archivists have tended to see legal records as meaning court records and what Bentham would have called pre-appointed evidence, so land registry records, deeds, and so on. And for instance, that business records of solicitors in England have not been perceived either by the archivists or by the solicitors as having archival value. And so, until about 4 years ago, the Business Records Council in England, concerned with saving a selection of business records, excluded solicitors' office records because, solicitors' records were deeds and so on. And so, part of what I'm talking about in a fairly serendipitous way is that there are a lot of misperceptions out there which anyone who has an understanding of evidence in law might pick up fairly quickly. But we need to think in terms of some sort of way forward. I absolutely agree with what Ron Allen said on the first day, that top-down grand theory of evidence in general wouldn't be a way of advancing this idea very far. There are some questions which are worth pursuing. For instance, do all forms of evidential reasoning in all these varied contexts, in different disciplines and different decisional contexts, do they all fit one model of practical reasoning? Is there a model of practical reasoning that can actually accommodate all of them? And with what variations and so on? And if there isn't, what are the implications of that for philosophical theories of practical reasoning? But I think most of the interesting stuff is probably at a less high level of abstraction and needs to be approached piece by piece. I think there is mileage in taking some of the, what for us are standard concepts, and then exploring whether they are used, possibly in different terminology, in non-legal contexts, non-legal disciplines, etc., and whether they're missing out on something. I think that Dave Shum showed rather convincingly that if you take, for instance, his tests for witness credibility, you could apply these in all sorts of other contexts which haven't had such a sophisticated way of thinking about the credibility of witnesses. I had a look at this recently in terms of autobiography. Shum's tests of the reliability of the autobiographer as a witness fail autobiographers on all 4 counts. And at least there is a workable set of concepts for using in other contexts. I would like to have a look at some of these industries of evidence-based medicine and evidence-based policy, because I think, and this was Trish Greenall's criticism of the early evidence-based medicine, what happened was in the early days, and then they edged out from it, haven't fully edged out from it, they were looking about evidence of strong probative value without any reference to evidence of what. So they were looking at the evidence producers, but not the evidence users. Well, now in medicine, there are quite a lot of examples where it's pretty obvious, commonsensical. Medical knowledge can tell you what the use of this might be from the very beginning, but it's not true of all areas of medicine. And so, why are you producing this? You ask the producer, why are you producing this new kind of evidence? They say because it's methodologically purer and sounder, better than previous examples. And, but of more probative value to what? There's a rumor, because I don't know if this is true or not, that when DNA came into public awareness, some members of the criminal community, particularly burglars, were terrified. They thought that this is going to be the end. And then one of them went to a pub where some of his colleagues regularly smoked, and before going on the burglary, took an ashtray full of ash and scattered it at the scene of the burglary with all the DNA of people other than himself. That was, and the whole history of DNA, particularly I think in the United States literature, has moved away from the idea that DNA somehow was magical. In the burglary example, DNA is mainly evidence of opportunity. And so the first move against DNA was a good one. You just produced evidence of all sorts of other people having opportunity by scattering the ashes from their cigarettes. And the whole DNA literature, particularly defense literature in America, on ways to counter DNA evidence has become really quite sophisticated. But no question that DNA was a great advance and made a great deal of difference, as have other advances in forensic science. But if one had looked at the development of forensic science and the development of certain other kinds of stronger kinds of evidence, from a user's perspective, there might have been a really quite different view on what was important and what not. Quite often, common sense gave you a bit of a thing, but a more specific thing that we really want to strengthen our investigations of this or that, starting with the user point of view, particularly in regard to policy, might be very illuminating. Right, well, my message is essentially, you, have got quite a lot to be proud of, and a lot to offer, and a lot if you encounter people in other disciplines or other spheres of activity, and you start asking about how they go about reasoning from evidence, you might have something to contribute.
I thank Professor Twining for a very interesting presentation, which concludes in fine style the presentations of this last session. He made us better understand the need of a multidisciplinary approach and an interdisciplinary comparison to the study of evidence. It is an opinion that I have always shared. Professor Twining also presented us with the difficulties of setting up a multidisciplinary research, but he did not fail to signal a way ahead for future activities. This is a baton that must be taken up by younger scholars. And I know that at least some of you here present today will be willing to continue along this path. Now we come to the discussion part. Okay. Please.
Professor Twining, I would like to know if there is any connection between the topic connecting the dots and the complexity that Professor Allen mentioned yesterday. Thank you very much.
Well, Ron Allen addressed several topics, but if it's to do with complexity theory, I don't have much expertise in this, so I did have a friend who was a pioneer in chaos theory, which is probably closer to my temperament. It's part of complexity theory. But one of the things that I have learnt in really playing around in this area is that quite often people in other disciplines don't really address or realize how complex arguments from evidence can be. What was called fact management in the Inns Court School of Law in London, and of which Wigmorian analysis is one example, nearly all predicated on a model of argumentation which can involve, usually using kind of propositional logic, which can involve hundreds or even thousands of propositions. And the main function of fact management is to organize information. Well, there's a lot going on in information sciences about organizing information, but I don't know how much of that is related to organizing it in the context of argumentation, rather than, say, having chronological tables or classifying information by source and certain other kind of thing, as the medics are tended to do, by strength. And so I'm very sympathetic to Ron Allen's thrust of emphasizing complexity. I have, however, said now more than once that I think he and I probably disagree about the concept of relevance.
Okay.
Thank you, Professor Twining. I was wondering how your words about what legal evidence field can offer to other disciplines interested in evidence can be applied to the communication or dialogue between forensic science and the legal realm, because the days before we have heard about problems of reliability of forensic evidence, and also problems of communication between forensic science or forensic disciplines and legal experts. And it's quite, in a sense, it's quite surprising because forensic sciences developed for the forum of legal process, so very near from the discourses on legal evidence. So I would like to hear if you have some comments on this relation. Thank you.
Well, first of all, as we all know, forensic science has developed very fast and in very important ways in recent years. The institutionalization of forensic science has kept it in England, but not in Scotland, has kept them separate, and they've had different cultures and so on, and then there's been all sorts of reorganizations of forensic science in England. There's been some very interesting work by Paul Roberts and a number of statisticians about the use of statistics in forensic science, and Paul Roberts is himself a lawyer, in fact an evidence scholar. I'm sorry he's not here. And I think there is a convergence, whereas in Edinburgh, for instance, there's a long history of forensic science being in the law faculty, and very close relations, and law students having courses in forensic science. Beyond that, I would be very interested to know about developments elsewhere. I've spent some time in the Netherlands, and there again, we went to the most important forensic science laboratory, and it was separate from law faculties and other things. And so, in terms of culture, sort of disciplinary culture, I think there has been quite a divide. But in terms of the concepts, the uses of forensic science in legal contexts, except they're relevant to other contexts, there's always been a close connection, and I think it could be refined by slightly more sophisticated working theories, but on the whole, DNA and all the other kinds of advances in forensic science have made a tremendous difference. But I do think the police ought to take logic seriously.
Gracias. Felicitaciones.
Thank you very much. Congratulations, Professor Twining, for your presentation, and thank you for your answer. In fact, part of what I wanted to ask has been asked already by Professor Daniela, so I will reduce or summarize my question to just a fragment of the same concern. Both forensic sciences, on the one hand, and all other disciplines, on the other, when they are introduced into a specific judicial moment, have found it difficult to have a transaction or to speak the same language, to have a common language so that communication were possible between them. Science, and as long as a discipline is very far away, well, tends to use a more sophisticated technical language, a highly specialized language. And this leads, at least in my country, in Peru, to a divide. It leads to a situation in which the judge takes everything or nothing, or the judge takes or accepts everything coming from the expert, everything that forensic science is giving, because he or she doesn't understand it. In the same way as police agents don't want to study logic, one would say that the actors of the judicial procedure are not interested in studying science. And so it's all or nothing. So either it's all over and above the heads of the experts, and then the judge doesn't understand it and rules it out and doesn't accept it, and then simply decides on the basis of something else. Do you think there's a way to overcome this divide, this distance in language between the experts in some sciences and then the forensic scientists and the judge? Thank you.
Well, insofar as forensic science is being used in legal proceedings, litigation, criminal, civil, the decisions by fact finders have to be made on a basis that they understand. And so to some extent, the problem of translation is a problem of translation into the world of the adjudicator, whether juror, judge, administrative judge, or whatever. Understanding the process, the context in which forensic science or other scientific evidence is introduced is really quite important for the experts doing the introduction. And so one thing is there's more to being a scientist than understanding your own science. If you're, in this case, the recipient of the evidence is the fact finder, and the fact finder, why the English courts have excluded Bayes' theorem mainly, but the main reason has nothing to do with the validity of Bayes' theorem. Some of it's to do with the conditions under which Bayes' theorem might apply, but some is just a basic principle that the decision maker needs to understand the language on which they are going to base their decision. But some of this is to do with culture. One of the difficulties we had in this great multidisciplinary project is that academic cultures are very different. And some of these are to do with expectations and to traditions and so on. And cultures have separate tribes and territories, one way it's been talked about, and tend to be very territorial. One of the difficulties we had in the UCL project is most people fitted into a model of cross-disciplinary work which there's quite a long, big literature, model of people going out from their field, taking something, taking it back in, rather than, as happens in other contexts, for instance, going out to join a team to build a bridge, which is a quite different model, where all the people from different disciplines really have to work together as a team. So it tended to be, as it were, going out and bringing something in and not getting into the cross-disciplinary communication context that you want to. And one of the problems of cross-disciplinarity is this sense of territoriality. This is my patch. I'm the expert. We lawyers, however confident we are about what we have to offer, shouldn't sound imperialistic, telling people how to behave. I don't think one should go to the evidence synthesizers and say, well, actually, you've got it all wrong. But I think with forensic science in particular, there could be ways in which, and maybe in some places this has happened, a greater acculturation to the two contexts would help communication a great deal. Yeah.
Gracias, Professor Twining.
Thank you, Professor Twining. Thank you. As to the title of your conference about this multidisciplinary aspect of evidence, could you now, well, I've been thinking that the concept of evidence is often confused with the name itself, because it's one same thing. And then maybe it's the kind of, by excellence, the most prodigious affirmation about God's existence, evidence. Those of us who have the full conviction of faith in the theory of creation and who have God as the cause of the existence of human beings must know that on the basis of our own existence, we acknowledge the existence of God. We cannot believe that evolution is in itself of a higher rank in order to deny the theory of creation, because in evolution, the lack of reason becomes reason itself, and it isn't rational if you accept the expression. So I wanted to hear your opinion about this very specific aspect on the fact that human beings are a way of evidence, or an evidence per se of God's existence. And the degree of rationality that this standpoint offers is of the highest possible rank, in that it is acknowledged as a being with reason and understanding on the basis of a higher being such as God.
Well, there's been a big and continuing debate, and it will probably go on forever, but recently with Richard Dawkins, zoologist, being the most prominent and quite outspoken defender of an evolutionary scientific view about, to start with, the age of this planet and the age of the universe, and then going further back into kind of questions that astronomers and so on look into, which he is himself an evolutionary biologist and very much wedded to evolution theory. And I think that the structure of his argument is quite interesting, because he thinks he has shifted the burden of proof. So he said, here, I've got a really good, plausible case to give an account of how we got to where we are and about possible origins and so on, and a lot we don't know, but we do know, for instance, we have a lot of hard facts about the age of this planet. And that seems to go against quite a lot of received religious teaching. He assumes that by evidence, he has a view of science in which only certain kinds of information count as evidence. So he won't accept revelation, for instance, as evidence. When you get to God, you get into all sorts of other theological problems about just interpretation. But there are certain facts in Dawkins's claim which sound much more like down-to-earth empirical facts. There does seem to be a fair amount of consensus since Darwin, and so going back to the 18th century, so in the history of this in the English-speaking world, the whole language and theory of probabilities emerged out of debates about proof of the existence of God. And there's a so when people have repeated many times in this conference that we are dealing with probabilities, not certainties, quite a lot of theologians will accept that. How probabilities are assessed and what counts as a source for belief is obviously still strongly contested. It's a really interesting body of literature on miracles. And quite a lot of the writing about miracles and proof of miracles and establishment of miracles, etc., centers around conceptions of evidence and conceptions of evidential reasoning and so on. My understanding, because I'm not very familiar with this, is that the division point is that for a miracle to be accepted, say within the Catholic Church, it has to be unnatural. It has to be beyond nature or contrary to nature. If that is correct, obviously someone like Dawkins is not going to accept that, because our knowledge is derived, our empirical knowledge is derived from our knowledge of nature. And he's prepared to expand his concept of nature to include a certain amount, but in the end, you know, there's a divide there. But for a lot of people, the concept of faith is distinguished from the concept of belief based on evidence. And the whole concept of belief and commitment and all the other associated concepts leaves empirical understandings of evidence aside. In other words, faith is a different basis for belief from evidence as we have been discussing it here, or as Dawkins accepted it, etc. And so they're different worlds and can live together with them.